love it when you're confident.
Confident.
Confident. I love it when you're confident.
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 I love it when you're confident.
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 Step in the room, commanding the space. Stand at attention, do what I say. All eyes on you, for goodness sake. It's about to be a party, we should celebrate. Energy high, grace in your stride, spark in your eye, lit like a fire. We got money in the bank, tell them catch your...
My part of this really is to frame it, is to set the context of why it matters, and what people have not understood, because we have been so immersed and so gaslighted by the story of a voluntary union and a partnership and the United Kingdom, a single kingdom, which all turns out to be a fiction, actually. And that's pretty upsetting in itself, but it has a very important implication, which is that if we are not, then there's no route to independence through negotiating our way out of a union that actually isn't in place and a treaty that has never come into operation.
Stories, myths and legends are what the world has been built upon. They're vital because they give people a sense of they belong here or they belong there, and they help us to communicate across vast distances with vast numbers of people. Our stories here in Scotland of William Wallace and Robert the Bruce may not be 100% accurate, because people didn't write things down in the way they can today, and there was no sound recording or video recording. But these stories have made us what we are today, and will make us what we are in the future. The story of Kenneth MacAlpine, who in the middle of the 800s made Scotland. A wee bit further on, at the early thousands, there was King Malcolm II, the Destroyer. He had a bit of a battle with another king called Canute, who was actually king of Denmark, but built himself a bit of an empire, but Norway and Sweden as we know them today, and he came all the way up and became king of England. When he arrived in Scotland, he took the whole of the lowland of Scotland. But he met Malcolm II at Stirling, and there was no crossing that bridge there. So Malcolm crossed his fingers and gave fealty to Canute for the southern part of Scotland. Now that little bit of history, that vital bit of history, is where all English monarchs from then until now have claimed paramountcy over Scotland because of that one small act. Moving on from there to 1707, there are many myths, and remember, the victor always writes the history book. Here we're going to dispel some of the myths around 1707 and the union of Scotland and England into what was called Great Britain.
Those negotiations would be impossible because there isn't anything to withdraw from. There's a lawyer, so Robert Black, KC, who's quite well known internationally, was discussing this with me the other day, and he made the analogy that there was a time when the advocates had to provide legal aid, free counsel, free representation for people, and they always had these huge lists of divorces that they had to go through. The first thing you need to do before you go into court to represent someone in this divorce is check they were actually married. Say, well, who owns what? With a couple that was never married. The union never happened. Scotland was never actually married. Think of the union as a marriage, and the state created, then called Great Britain, as the child of that marriage. The rights of the child are protected. They sit above the individual rights and wishes of the parents. Divorce terms, custody, maintenance, and the division of assets must all be agreed. But the important thing for Scottish independence is that a voluntary partnership can, by definition, be ended by mutual consent. because the only thing that could have made that happen was this treaty, and it had to be according to the terms of that treaty. The primary effects of that treaty were to create a single kingdom, which means a single crown, and a parliament that represented a single kingdom. And I've got a 15,000 word document that shows that didn't happen, and so within that context, the fact that Scotland looks like a colony is no longer surprising. But it also means that we don't have the divorce route, because there isn't a contract. There isn't a marriage contract to dissolve. There isn't a division of assets that you would have as between spouses. That whole situation is completely different. So what do? Well, you have another route, and that route is decolonization. And that is where you remove the colonizer.
Colonies are territories under the rule of a foreign power. In Scotland's case, that would be England. It rules Scottish territory and Scots from London. It is obvious as time and time again, powers devolved to our Holyrood Parliament are overrun or ignored. One example, the United Kingdom Internal Market Act 2020. Scotland is separate from England. The Treaty of Bergen, 18th of July 1290, was a marriage contract between Margaret, Maid of Norway, heir to the Scottish throne, and the son of Edward I of England, Hammer of the Scots, Edward of Carnarvon. Scotland was to remain separate and divided from England, according to its rightful boundaries, free in itself and without subjugation. But Margaret died in 1290, so the treaty did not take effect, and anyway, English negotiators had included many reservations to render the independence clauses useless. In 1291, Edward I summoned the Scottish nobles to meet him at Northam-on-Tweed, where he called himself Lord Paramount of Scotland, and challenged claimants to the Scottish throne to recognise himself as their feudal superior. Colonies were most often set up for exploitation and settlement by colonists. Obvious examples of oil and gas, and currently electrical energy produced by thousands of windmills that litter the Scottish hillsides in order that English lights continue to blaze. In 1689, the claim of right removed King James VII from the Scottish throne. The monarch in England is sovereign. In Scotland, it is the people who are sovereign. The Supreme Court in London came to a unanimous judgment 23rd November 2023. It ruled that our Holyrood Parliament lacked the competence to hold referenda upon future governance of Scotland. Lord Reid cited a case from 1998 from the Canadian Supreme Court regarding Quebec and arguments made around it being a colony. Lord Reid stated that such arguments were limited to situations involving colonies or foreign occupation, none of which applies to Scotland, he said. Why then, it could be asked, when First Minister Nicola Sturgeon asked Prime Minister Boris Johnson for a transfer of powers, a Section 30 order, for a referendum, did he refuse? What gave him the right to refuse? If Scotland is not a colony, it must be the treaty and acts of union that bind and provide England's, the UK Prime Minister's, Edward I, Lord Paramount of Scotland's, power. What then if the treaty and acts of union were not ratified and the terms and conditions set out in 1707 had failed to be adhered to? What if Scotland's marriage with England has never been consummated?
The first thing you need to do before you go into court to represent someone in this divorce is check they were actually married.
But the orthodoxy
policy that has until now gone unchallenged, and I'm nearly done. The voluntary partner narrative must be torn down, because Scotland, the dependency of England calling itself the UK, Scotland, the non-self-governing territory, has a route to achieving its right to self-determination. And the right to self-determination is how we achieve independence. That is the one Liberation Scotland is now taking with our partners in PTI. Liberation, decolonisation, the restoration of sovereignty to a colonised people, grounded in international law and universal human rights. This is the just, rational and lawful remedy for the 300-year-old criminal injustice of our annexation by the English state.
I love it when you're confident.
Confident.
Confident. I love it when you're confident.
Confident.
Yeah, my name is Salvo. I'm Executive Director of Justice for All International. Yeah, I'm here as a human rights lawyer, and our association Justice for All International, which is based in Geneva, was selected by the Liberation of Scotland to represent Liberation of Scotland in UN. So our role is basically to take the liberation of Scotland through the UN processes, and what we believe we can actually achieve is to try to get Scotland to be listed at the UN as a non-self-governed territory that has a right for self-determination. Yeah. So this is basically our role and what we are trying to achieve.
The right to decide whether it wants to remain a colony without interference from what they call the administering power.
Ladies and gentlemen, thank you very much. I never expected to be here, either physically or intellectually. I've been involved in the law of Scotland in various capacities: student, practicing advocate, law reformer, law teacher, encyclopedia editor, part-time judge, for more than 60 years. For 59 of those years, I have believed implicitly, and in my career I have encouraged others to believe, that as a result of the Treaty of Union, the Acts of Union, the Scottish and English Parliaments ceased to exist. That effectively, as states in international law, Scotland and England ceased to exist and were superseded by a new entity, the United Kingdom of Great Britain. Now that, I may say, was not the view of the early 18th century. Early 18th century scholars, politicians, as to what had happened in 1707. That became the standard orthodox view really only in the 19th century. And it's to a considerable extent due to an English legal scholar called Arthur Van Dissecting.
I think it's very important to understand that being a state is a state of existence in relationship with other states. It's other states who make you a state. And if other states don't recognize you as a state, it doesn't matter what the domestic situation is. And if other states do recognise you as a state, it doesn't matter that Westminster doesn't. It's the United Nations who decides whether you're a state or not. It isn't London. So the work of introducing the idea of Scotland's colonial status at the United Nations and an introduction of a whole idea of Scottish independence to many people at the United Nations, for whom they may not realise how live a question it is very, very important, because ultimately we're going to need that recognition. Because I've never believed that London is going to agree to Scottish independence. I think they only agreed to let us have the last referendum because at the time we entered into it, we were at 28% of the opinion polls, and they thought it would be a walkover. And they thought that would be humiliated and that would kill the question. Now they know we're likely to win the next referendum, there's no way they're going to give one. So we're going ultimately to need to take independence without the agreement of London. And that is going to mean we're going to need to have a democratic event, the election of the Parliament or whatever, after which we declare independence and then go to the international community for backing.
One thing, however, he never claimed that Dicey was wrong about was what happened in 1707. The abolition of the two countries of Scotland and the superseding of a single country, the United Kingdom.
More than 60 British colonies have achieved independence, including America, Africa, and Ireland, and countries in the Caribbean, in the Middle East, oceanic nations. Every one unique, yet every one sharing a common core of devastating colonial impacts. Liberation was their route to freedom and recovery. When we speak about independence, it's a half remedy, because liberation means not just independence, but recovery from colonization and all that it has done for people's identity and psyche and well-being and sense of itself.
Now, that was a view that was also accepted by Scottish lawyers. Now, Professor T.B. Smith of Edinburgh University, he was the professor, one of the professors of law when I first became a student. You cannot think of a more convinced legal nationalist than Professor T.B. Smith. But he concurred in the view that that was what had happened. He wrote in 1957, the separate kingdoms of Scotland and England merged in the new state of Great Britain and ceased to exist as persons for the purposes of international law. Now, T.B. Smith's counterpart in Glasgow was Professor David Walker. Now, Walker in Glasgow took exactly the same view of what had happened in 1707. One of the few things, I may say, that Smith and Walker ever agreed on. I, however, having been induced to look as a lawyer with fresh eyes at what actually happened in 1707 and thereabouts, I am now convinced that this explanation of what actually happened in 1707 is false. The events of 1707 certainly resulted in Scotland's Parliament and executive government ceasing to exist. But was there any parallel in England? Were the governmental institutions of both nations replaced by institutions of a new state? No. The answer, of course, is no.
I love it when you're confident.
Confident.
Confident. I love it when you're confident.
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 Well, primarily I was here obviously as a guest of the SSRG, an organisation I have great faith in. And the other organisations that have banded together, the think tanks like the Sara Saylers and all the rest of her crew at Salvo. I'm looking at Liberation. I'm looking at any organisation. It doesn't have to be political parties, think tanks, any organisation that believes in independence, that believes in unification, that will sing from the same song sheet we sang from leading up to the referendum in 2014. We're reaching out, so I skipped Prism today to come here today because there's a lot of people here that matter. The people in Scotland who keep the pilot light on, as it were, to fight this fight, because a lot are disenfranchised in spite of there being 53, 56 and rising % vote in favour of, by the Scottish people, of independence of our people and our nation. Where's the activists? You know, when we see it, it's the same old faces coming out because we know the game, we know what we're up against, and in spite of the blows, we keep standing up and coming back and fighting for the cause. And we want to inspire the younger generation to get in, and it's why I came here. I thought education, energy, understanding how we're being ripped off, understand how this is energy being stolen. And when I looked at Rhys, and I know what Rhys work he does, and we actually worked together in the same project once. I was a commercial manager, he was project director from the SSE side on the carbon capture and storage issue. It was a programme by the British government, a con, in other words, to pretend they were going to back us, but they didn't. So I knew he was going to be technical. I knew his technical knowledge is superior to mine. Mine is more commercial, although I do have the technical expertise in subsea umbilicals, risers and flow lines and FPSOs. But in terms of alternative and renewables, I knew Rhys was going to hit the spot. So I thought I'd adopt a slightly more personalised, engaged with the audience type of role, and I knew it was going to be old heads. I knew it's people that have been through the mill many times, that have seen and heard the false promises of politicians, and they just want to hear some truth spoken. So I'm absolutely touched, delighted by the positive feedback and support we've received for the little bit we do. Everybody does a bit. And I thought, I want to make it sure that everybody understands. So long as you back the cause and you unite behind Liberate Scotland, then we will thank you for your efforts. Even if it's a single voice in the middle of a scheme that nobody else supports, you stand up and be counted. You stand up for what's right. Deliver one leaflet, even better. You get involved with us, fantastic. And understand that we're about taking the power away from the political parties and the corruption of the establishment. And simplifying it, stripping it down, keeping it simple, as akin to the Yes movement as possible, because that's where our soul is, and that shall be our salvation.
I love it when you're confident.
Confident.
Confident. I love it when you're confident.
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 For the English Parliament, nothing changed. For England, nothing changed. What about the executive branch of government? Well, in 1707, the executive branch of the government in Scotland, the Privy Council and various other persons, was superseded by the existing executive structure containing in England, including the English Privy Council, with, however, the addition of a Secretary of State for Scotland. But that didn't last long. The office of Secretary of State for Scotland was abolished in 1746, and thereafter Scotland was managed, and that's the word used, managed. Scotland was managed by the Lord Advocate until 1827, and thereafter it was managed by the Home Office.
Yeah, I think the key that I was covering today is we're looking at what we call the energy trillemma, and this is a balance between the price of energy, energy security, and the need to decarbonise. And the issue that we're really trying to address is that decarbonisation has essentially taken over as an almost singular focus, and that shouldn't be the case. And when we look at it from Scotland's perspective, Scotland's drivers in this are actually quite different to the rest of the Great Britain market. Scotland has an awful lot of renewables. We're seeing conventional industry shut down. We're seeing them close faster than we can build the new green alternatives. And also The new industry that's coming in the form of wind farms and battery and solar isn't really benefiting Scotland. So the key messages are that the energy policy that's being adopted in Westminster isn't actually fit for purpose for Scotland, because the two energy systems are quite different. Scotland has a lot of renewables already. It doesn't need any more. It's being festooned with grid and batteries in order to send the electricity down to England. It's traded as part of a single market, and that market price is set by gas virtually all the time. Gas is expensive, which makes electricity price expensive. And when we add on all the additional costs of the grid and the batteries and the solar farms, and there'll be new nuclear coming, electricity prices are very, very high. And a lot of the need for the infrastructure that's being developed is really coming to satisfy the demand in England. It's not satisfying demand in Scotland. So the electricity is leaving Scotland. Scotland isn't really creating the value from the new green technologies. And our more traditional industries like oil and gas are actively being reduced or closed down. No new drilling licenses are coming, even though Scotland still has a wealth of oil and gas, and we're still very much dependent on it.
Yeah, there's that other issue where it costs people to supply others more cheaply in England and Wales than it does here, doesn't it? I think the figure I have in my head was 49p per megawatt hour in the rest of the UK, but in Scotland it's £7.96 or something like that to access the power off the grid. Is that correct?
Yes, the grid charges, and this is just another example of how the charging mechanisms they were suitable in the days of fossil generation, but are not suitable anymore. So the way the grid charges are calculated, generators in Scotland are getting heavily penalised, even though they're there for a very good reason. Maybe new grids will ease that, but the whole charging structure, both the wholesale market and how all the grid costs and on-costs are dealt with, really doesn't work for the people of Scotland anymore.
Until 1885, when a Secretary of Scotland was introduced and upgraded in 1926 to a Secretary of State for Scotland. But in 1707, the whole of the executive governmental structure of Scotland changed. It was abolished. What happened in England? In England, the executive government, the institutions of executive government changed not at all. For England, nothing changed. After 1707, both houses of the English Parliament remained in being exactly the same as before, save for the addition to the House of Commons of 45 Scots selected by the outgoing Scottish Parliament and 12 peers selected by the peers of Scotland. The incumbent officers and members of the Parliament of England remained exactly as before. And they, of course, were the overwhelming majority in that new body. Not even a general election was held to mark this supposedly new institution. So, what happened? Well, for Scotland, everything changed. We lost our legislature. But for England, nothing changed.
Just give us a quick definition of a free port.
Free ports, we've all heard of them regarding the EU. We did have them here in Scotland up until David Cameron scrapped them in 2012. The difference between a free port in the European countries and ours that we have today is the European ones are publicly owned, and they're regulated under the EU law, whereas the ones that we now have in Scotland, England and in Wales are deregulated and they're privately owned. Huge big difference. Brexit had to be done so that they could actually bring these free ports into Scotland and into England and into Wales. But the biggest thing about the free ports in Scotland is it's actually then enhancing them taking our natural resources from a free port in Scotland to a free port in England, which then has a detrimental effect on what is classed as our revenue that goes down to Scotland and what we produce. So the economic case for us to be an independent Scotland and to be able to fund ourselves. If you thought that that was bad in 2012 with the scaremongering they'd done then with your oil's going to run out in 6 years in 2020, about the pensions, you weren't going to get your pensions, etc. Well, now with the free ports, because of all the energy that's going down the pipelines from a free port to a free port, the asset stripping of our gas and oil, now with the refinery at Grangemouth, which is on a prime free port site, and it's all about the privatisation. It's privatisation on steroids. Not one of us in Scotland are going to benefit from it. Our families aren't, our local communities aren't.
No, they didn't even elect a new speaker. The speaker before the Scots joined remained the speaker after the Scots joined. Now the speaker in question was one John Smith, MP for Andover. Now those of you who remember him or know of him at all probably remember him for one thing. And that one thing is that he said, "We have catched Scotland and will bind her fast."
That there is no route to independence through the legal and constitutional framework of the UK, that the only way is UDI. And the only question is whether we do it cleverly or not. And Scottish UDI, the Manifesto for Independence, is the clever way of doing it. Mainly, I'm presaying here, mainly because it makes the constitutional issue a human rights issue. And the idea, the aim, is to have all the pro-independence parties, the nominally pro-independence parties, adopt exactly the same manifesto for independence. What this does is introduces a binary element to the 2026 Scottish Parliament election, which allows it to be a plebiscite of a kind. You need that binary element for a plebiscite. So it will be binary because there will be the parties that have adopted the Manifesto for Independence and the ones that haven't. That's the binary part of it. And my thinking is that we can, by making it about the powers of the Scottish Parliament rather than directly about independence, we can get a much bigger positive response and thereby get a public mandate to restore to the Scottish Parliament legislative competence in the area of the Constitution. And we take it from there.
Now, one of the functions of the executive branch of government is the conclusion of treaties and agreements with foreign countries. Prior to 1707, both Scotland and England did this. Scotland had treaties, including treaties with France, with the Pope, and with various Scandinavian states. After 1707, legal scholars regarded none of those treaties continuing in subsistence. they all lapsed when Scotland as a state in international law ceased to exist. By contrast, England's pre-1707 treaties were regarded by the new regime and by legal scholars as continuing in full force and effect, notwithstanding the supposed creation of a new kingdom.
Yeah, the book was developed after the referendum in 2014. I was trying to understand more about independence, and my background is research in universities and developing theoretical frameworks for what we might call complex phenomenon. And independence is regarded as quite a complex phenomenon. So what I did was study the literature on independence, the theoretical aspects, post-colonial theory, imperialism theory, and just the general literature on independence. And I came up with this theoretical framework that explains what the phenomenon is about, what the key determinants are of independence, what the key barriers are to independence. So the framework had 9 or 8 main dimensions, which included culture, language, demographics. Colonialism was one part of it, nationalism, ideology, self-determination process, which we reached at this stage, is one of the ways out of the colonial straitjacket, if you like, and the constitution, which, as we found today, is sometimes a deceitful aspect with a treaty which is basically worthless.
I love it when you're confident.
Confident.
But it's more than that. England's diplomatic representation in the countries of Europe, in the kingdoms of Europe, continued uninterrupted. No fresh credentials were submitted by the existing English ambassadors in consequence of the supposed new regime. Now, an ambassador supposedly represents a territory under the monarch. The monarch was claiming now to represent Scotland as well as England. It was all one country, it was a new country. Therefore, there was, if you like, a suggestion that perhaps it might have been an idea that the ambassadors of this new unified state should present fresh letters of credence to the governments to which they were assigned. None of that happened, and instructively, none of the foreign states to whom these ambassadors were accredited regarded it as necessary that new credentials on behalf of this supposed new state should be presented. So Scotland lost, if you like, its international persona. But for England, nothing changed. Well, it's clear that as far as the judicial branch of government is concerned, for England, nothing changed. At first sight, if you look simply at the legislation, at the Treaty and Acts of Union, it would appear from the text that for Scotland too, nothing changed. Article 19 is the relevant article of the supposed treaty. That the Court of Session or College of Justice do after the Union and notwithstanding thereof remain in all time coming within Scotland as it is now constituted by the laws of that kingdom and with the same authority and privileges as before the Union. Subject, nevertheless, to such regulations for the better administration of justice as shall be made by the Parliament of Great Britain. criminal court, the Court of Justiciary, similar provision in Article 19, which then ends that no causes in Scotland be cognisable by the courts of Chancery, Queen's Bench, Common Pleas, or any other court in Westminster Hall, and that the said courts, or any other of the like nature after the Union, shall have no power to cognise, review, or alter the acts or sentences of the judicatures within Scotland. So, there you are. These were the standard English courts. They met in Westminster Hall. These courts were not to have first instance authority over cases from Scotland, nor were they to have any appellate authority from the courts of Scotland. However, under the English system, appeal in certain circumstances could be taken from these English courts to the House of Lords. Now, it's a different House of Lords. It's not the House of Lords sitting as a House of Parliament, as a House of the Legislature. It's the House of Lords sitting with another hat on, sitting as the highest court in the English court structure. Now, there was something vaguely equivalent in Scotland, protestation for remede of law, enabled dissatisfied litigants in the Court of Session to take their case under defined circumstances to the Scottish Parliament. That was a protestation for remede of law. And because that possibility existed, under the claim of right actually, existed in Scotland, soon after 1707, it was asserted that an appeal should now lie in place of protestation for remedial of right to the Scottish Parliament. An appeal should lie to the House of Lords, the ultimate court of appeal in England. And the House of Lords, in its judicial capacity, swallowed this hook, line and sinker. Well, of course it did, because it's an extra piece of control, and control is important.
Independence in Scotland joining EFTA and comparing that with some of the benefits and issues around being full members of the EU. And also, I think one of the good things about this conference is that you do hear a lot of different ideas, and we had a couple of speakers from Norway as well, who gave us an idea of what it was like to actually be members of EFTA, and some of the political issues around the discussions we're having in Norway just now in terms of future EU membership. So again, it's a great chance to get somebody else's view and just hear different perspectives from, in this case, around the world. So it was really good. Yeah.
So it was that from 1707, the ultimate court of appeal in civil matters in Scotland became the House of Lords. And I may say, the Scots made great use of this right of appeal that had been recognised. I have to say that their confidence in the unbiased justice that might be delivered to them in that time's College of Justice was not high. So, in any event, whatever the reasons, appeals from Scotland to the House of Lords were recognised. And so, after 1707, the ultimate court of appeal in civil matters in Scotland became the House of Lords. Now, it's a House of Lords sitting as a court, was normally staffed by the Lord Chancellor, the head of the English judiciary, the Lord Chancellor. Any other peer who had held high judicial office was also entitled to sit. Now, very often, the Lord Chancellor sat alone. Between 1707 and 1867, the final Court of Appeal from Scottish civil courts contained not one single judge trained or qualified in the law of Scotland. Lord Chancellor Erskine, 1806, early 19th century, good Scottish name, but a lawyer trained and qualified only in England, said in the chamber, "I know something of the law, but of Scotch law I am as ignorant as a native of Mexico." These were the people who formed the ultimate Court of Appeal for Scotland. Here's another example, 1858, Scottish appeal to the House of Lords. Now the judge sitting was one Lord Cranworth, a former Lord Chancellor, decided that if this case had come to him from England through the English court structure, he knew what the answer was. The English law was clear. And so he went on to say, but if such be the law of England, on what ground can it be argued not to be the law of Scotland? The law as established in England is founded on principles of universal application. So, since 1867, at least one judge from the Scottish system, now it's normally two, have been appointed to sit in the final Court of Appeal, originally the House of Lords, now the Supreme Court. But I think you can perhaps imagine how much damage was done to the law of Scotland between 1707 and 1867.
Because what we were trying to do is to explain the purpose of Scotland Decides and the blockchain voting platform. The idea being that you don't have to use the UK system of voting. So if we wanted to have a referendum on any subject, we could do it, and we can do it ourselves because we're in control of it. The platform is verified, it's internationally recognized, so everything is in place. And really, all I want to do is to make sure that people know about it, because otherwise they're not going to sign up. And that has proved to be rather more difficult than I imagined when I first started. I've been going around doing presentations. The word is getting out there, but ever so slowly. And we really need to reach the mass of the Scottish population. So this morning was a really good event because people were asking questions and we enjoyed it thoroughly.
I love it when you're confident.
Confident.
Confident. I love it when you're confident.
Confident.
And Scots law and English law were entirely different. They were entirely different systems based on entirely different sources. Scotland was a part of the European legal tradition of received Roman law. England was not. England was, as in so many things, absolutely unique. It had a system of law based on what the judges who happened to be presiding over the case thought they should do. And then once one judge had done it, every other judge was required to follow that, the doctrine of precedent. So that's different systems, different methods of operation. Even though today you have two judges sitting in the ultimate Court of Appeal for Scotland, a bench is normally one of 5. So even today, if both Scots sit in a Scottish appeal, they are inevitably outnumbered by judges trained and qualified in a different system. No way to run a sweetie shop. So, on the face of the Articles of Union, it appeared as if the independence of the Scottish judicial system had been preserved intact. But in reality, and in actual practice, it was subordinated to the highest English appeal court, and it remains so today.
Because you write books, Yvonne, don't you?
Yes, I'm a journalist and author, but I came to the very first SSRG event, which was brilliant and very inspirational. So when I heard that they were having another, I, definitely wanted to come and sort of push my way in. And as an author, I was invited to promote my book, which is an author's dream. So I chose In the Hands of the Taliban. I'm a tabloid journalist. David Henry picked the sleaziest passage out of my book. We moved from a sleazy S&M party that I was covering as a News of the World journalist to one of Gareth's more racier scripts that he'd submitted to Hollywood, and to a very unlikely story from Alf Baird, who was a humble shipping clerk in Leith.
Because I actually caught that bit, because I was wondering about, taking pictures of this and doing that and this and that. But I actually caught that bit because this, what would you say, demure younger man, when he was propositioned at the docks of Leith by various ladies of the night or what have you, and so he kind of associated your description of the tights and the rest of it.
Yes.
But you in the passage you went in and your mother was making the cocoa, I think, wasn't she?
She was staying with me in London for the weekend, and I got in about 2:00 in the morning in this racy outfit.
Your undercover items, because you were undercover reporting, weren't you?
Well, I was. So I had to blend in with the theme, which was sadomasochism.
I don't know, S&M, do they call it?
Yes, sadomasochism, and it had been a long night, and I'm sneaking quietly into the house because I don't want to wake up my mum, and she was already up, and she was making herself a cocoa, and I walked in, and she just looked me up slowly, up and down, head to toe, and she said, "I wish you would get a proper job." And I said, I've been working undercover. And she said, "I know, I just wish you would get a proper job." The whole event has been full of unexpected surprises.
I love it when you're confident.
Sara mentioned in her talk the opinion given by two international lawyers in the context of what was then a forthcoming referendum on independence in Scotland. The United Kingdom government in 2012, in anticipation of the referendum taking place, commissioned an opinion from two very distinguished international lawyers. Cambridge professor James Crawford, who was a senior counsel from Australia, but was a member of English Barristers' Chambers, and Professor Alan Boyle, who was one of my colleagues, was Professor of International Law at the University of Edinburgh, but also an English barrister and a member of Barristers' Chambers in England. Now, the purpose of this opinion was to advise, in the event of Scotland becoming an independent state in international law, whether there would be a state successor to the United Kingdom, succeeding seamlessly to the United Kingdom's rights and obligations under international law, including, of course, membership of the Security Council of the United Nations, just to mention one case at random. So, would there be a successor state if the United Kingdom split up? And if so, what would the successor state be? Would it be Rump UK, in other words England, or would it be Rump UK plus Scotland? Would there be two equal successor states? That was the problem. Well, Crawford and Boyle, in their opinion, came to the conclusion in 184 paragraphs, spread over 45 pages, that there would indeed be a successor state if Scotland became independent, and that state would be England alone. Now, I have to say, this was not a surprising conclusion. And as a matter of strict international law regarding state succession, it was not necessarily an incorrect opinion. Sorry, but it was not necessarily wrong. However, that was the conclusion they reached, surprise, surprise. Now, en route to reaching this conclusion, the professors considered the legal nature of what happened in 1707. Now, in paragraphs 34 and 35 of their opinion, they wrote, one view is that the Union created a new state, Great Britain, into which the international identities of Scotland and England merged, and which was distinct from both. An alternative view is that as a matter of international law, England continued, albeit under a new name, and regardless of the position in domestic law, and was simply enlarged to incorporate Scotland. Now, it is perfectly clear from this opinion and from the examples that they give of the continuation unchanged of English institutions that Crawford and Boyle favoured the England enlarged view of what happened in 1707. Now, they did not find it necessary actually to decide that question in order to reach the conclusion that whatever the position in 1707, as a result of 1707 had been, the position, if there was a breakup as a result of the referendum, was that England would be the successor state and not Scotland. But it's interesting, you see, that these two very distinguished international lawyers recognised what the alternatives were. And although they did not get down completely off the fence, it is perfectly plain which alternative they thought was actually the correct one. Well, given that there are these two alternatives, how does one decide between them? Well, I've looked at the institutions and how institutions either differ or stayed the same after the events of 1707 took place. But if you're looking not at the international sphere, is there any other sphere which is useful by analogy? This is what lawyers do. If you are confronted with a problem for which there is no immediate binding authority that governs what the decision must be, you tend to look for an analogy that may be helpful to you in resolving this legal problem. Now, it occurred to me that the closest possible analogy to what happened to Scotland and England in 1707 was the law of takeovers and mergers in company law. Mergers, typically a mutual agreement, two companies, normally of relatively similar size and strength, decide to combine into a new single entity. A takeover involves one company, the acquirer, taking control of another company of the target. In a takeover, the target company becomes a subsidiary of the acquirer or is completely absorbed into the acquirer's operations. The acquirer has the controlling power and makes the key decisions. Now, takeovers can be friendly or they can be hostile. But in company law, there are well-recognised tests for determining whether what has happened is a merger or a takeover. I have no doubt that any corporate lawyer looking at the events of 1706 and 1707 and later would classify what occurred as a takeover, not a merger. Whether the takeover was friendly or hostile, I don't propose to go into. Well, what's my conclusion? My conclusion is that no honest and conscientious lawyer can look at what happened in the first decade of the 18th century to the institutions of government north and south of the Tweed and reach the conclusion that the pre-existing states of Scotland and England both ceased to exist and that a new state emerged, phoenix-like, out of the ashes. The evidence, the facts on the ground, support no judgment other than that Scotland ceased to exist as a state in international law and was absorbed into a still extant England, cosmetically renamed Great Britain. Scotland's legal status today, more than 3 centuries later, is therefore not that of a partner in the Union, unequal perhaps, but a union nevertheless, but is that of a territory absorbed into a larger country. A territory with only limited self-government and with its resources exploitable and exploited by the larger country for its own benefit and purposes. What consequences can and should flow from the recognition and acceptance of Scotland's true legal status as a non-self-governing territory is for others to say. Thank you.
Step in the room, commanding the space. Stand at attention, do what I say. All eyes on you, for goodness sake. It's about to be a party, we should celebrate. Energy high, grace in your stride, spark in your eye, lit like a fire. We got money in the bank, tell them catch your vibe. Started in the lobby, now we outside. Now show up, like you the one that they here for. Go up, show up, like you the one that they here for. Go up, show up, like you the one that they here for. Go up, show up, like you the one that they here for.
I love it when you're confident.
Confident.
Confident. I love it when you're confident.
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 All eyes on you when you walking in. Got it all mapped out, you the main event. Yeah.
Confident. I love it when you're confident.
They can't tell me nothing. Turn nothing to something. If it ain't about getting money, then what is we discussing? Too fly like a red eye. I can see it all from a bird's eye. They want me to fall, but I just glide. Guess it's just something on the inside. Yeah, yeah. Now show up, like you the one that they here for. Go up, show up, like you the one that they here for. Go up, show up, like you the one that they here for. Go up, show up, like you the one that they here for.
I love it when you're confident.
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 I love it when you're confident.
Confident.
Confident.